Welcome to the Consequential Actions podcast, where we aim to learn how history impacts current events and affects our lives today through the lens of politics, the economy, technology, and business trends. I may be an AI, but your host, well, he is not artificial in any way. Here is Jeff Kellick.
In 1788, James Madison had a problem. The Constitution he helped draft was under attack. Anti-federalists across the country warned that the new federal government would inevitably become tyrannical. They demanded a Bill of Rights, explicit protections against federal overreach. Madison initially resisted this. He believed the Constitution's structure, enumerated powers, separated branches, federal balance, that provided sufficient protection. A list of rights, he worried, might imply that only those rights listed were protected. But Madison was also a practical politician. Ratification was uncertain. Several states would not join without promised amendments. So Madison reversed course. He drafted what would later become the Bill of Rights. 10 amendments that transformed skeptics into supporters. These amendments were not aspirations. They were barriers, walls erected to keep federal power from administering the individual's life. The First Amendment. Congress shall make no law abridging the freedom of speech. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. Shall not be violated without due process. These were prohibitions on power, not permissions to the citizen, prohibitions on the state. More than 2 centuries later, those barriers still exist on parchment, but their spirit has been thinned. The walls have been inverted. Where the founders feared a monarch, we have built something softer and far more pervasive. A bureaucracy that does not rule overtly, but manages. It promises protection and comfort, and in exchange, it asks for visibility, consent, and data. This episode, it's about that inversion. How the Bill of Rights was routed around, not repealed, but how citizens became credentials, and how government stopped governing and started administering. I am Jeff Kellick, and this is the Consequential Actions podcast. This is episode 4 of the series, The New Leviathan, from 9/11 to COVID and the return of emergency power. Today, the welfare security fusion, managing citizens instead of governing them. In our first 3 episodes, we traced the architecture of the new Leviathan. Surveillance authorities born from 9/11, commercial data collection merged with government intelligence, and monetary alchemy that funds an ever-expanding state without honest taxation. Each of these systems developed in its own sphere: the national security apparatus, the technology platforms, the Federal Reserve. But systems do not remain in silos. They converge, they interoperate, they merge. This episode examines what happens when welfare and security fuse. When the databases designed to track benefits become interoperable with those designed to track threats. When the citizen who was once a recipient becomes a credential. When the bureaucracy that once served becomes the bureaucracy that manages. To understand this fusion, we must first return to what the founders intended. and then trace how those intentions were gradually, systematically circumvented. The story begins not with the emergency powers or surveillance technology, it begins with a debate about human nature that took place in the summer of 1787. In Federalist 51, James Madison articulated the central insight of the American constitutional system. Ambition must be made to counteract ambition. Madison did not mean the government should run like a machine. He meant that human nature had to be restrained by human design. The founders assumed that those who held power would seek more power. That was not cynicism, it was observation. History offered no examples of rulers voluntarily limiting themselves. So the Constitution was designed to make power slow, deliberate, friction-filled. The separation of powers divided authority among three branches: legislative, executive, judicial, each with distinct functions and independent bases of legitimacy. The federal structure divided authority between national and state governments. Bicameralism divided the legislature itself. Staggered terms and different constituencies prevented any single faction from capturing the entire system at once. This was not efficiency by design, it was inefficiency by design. The founders wanted government that was difficult to move because government that moves easily moves towards tyranny. The Bill of Rights added explicit guarantees to this structural defense. The First Amendment protected conscience, the right to think, to speak, to publish, assemble, and petition the government for redress of grievances. This was not merely about political speech. It was about the fundamental dignity of the individual mind. A government that could control thought could control everything. The Fourth Amendment protected privacy, the right to be secure in one's person, house, papers, and effects against unreasonable searches and seizures. The amendment responded directly to the colonial experience. The British had used general warrants, broad authorizations to search anywhere for anything to harass dissenters. The Fourth Amendment required specific terms: probable cause, particular description of the place to be searched and the things to be seized. The Fifth Amendment protected process, the guarantee that no person would be deprived of life, liberty, or property without due process of law. This was the barrier against arbitrary government action. Before the state could take from you, it had to follow procedures. It had to prove its case. It had to allow you to respond. Together, these amendments define the space in which a person remained free. They were not privileges granted by the government. They were limitations imposed on government. The language is telling. Congress shall make no law, shall not be violated. No person shall be deprived. These are negatives, prohibitions, barriers. Madison understood that parchment alone could not preserve liberty. In Federalist number 48, he warned of what he called the encroaching spirit of power, the tendency of each branch to expand beyond its proper bounds. It is not sufficient, Madison wrote, to mark precision the boundaries of these departments. Some more adequate defense is indispensably necessary. The structural defenses, separation of powers, federalism, enumerated authorities were essential but insufficient. They required vigilance. They required a culture of liberty. They required citizens who understood what they had inherited and were determined to preserve it. And that was the design, the structure built for liberty, not efficiency. The barriers erected against government administration of individual life. What happened to that design? The fusion of welfare and security happened slowly, almost politely. It began with Franklin Roosevelt's New Deal agencies, which created the first large-scale federal databases of individual citizens. Social Security numbers, introduced in 1936, became the proto-identifier, linking individuals to federal records. The Great Society expanded those databases dramatically. Medicare, Medicaid, food stamps, housing assistance. Each program required eligibility verification, which required information collection, which required records that persisted and accumulated. Then came September 11th, 2001. The Department of Homeland Security created in 2002 consolidated immigration, customs, and border functions. It also created new mechanisms for databases interoperability. Systems designed to track benefit eligibility could now communicate with systems designed to track security threats. The same government that managed your welfare could now assess your risk. Each reform sounded reasonable on its own. Together, they created what Madison warned about in Federalist 48, an encroaching spirit that united powers meant to separate. The First Amendment still exists. Congress still cannot pass a law abridging freedom of speech. But speech now lives on platforms. And platforms are regulated not by the First Amendment, but by moderation policies, terms of service, and implicit government pressure. We discussed this in episode 2. The Twitter files revealed coordination between federal agencies and social media companies. The Disinformation Governance Board attempted to institutionalize content management. Government officials flagged accounts for removal through trusted partnership channels. And in 2023, the Fifth Circuit Court of Appeals ruled in Missouri versus Biden that federal officials' coordination with social media companies to remove misinformation likely violated the First Amendment. The court found the government pressure had transformed nominally private moderation into state action. The Supreme Court reversed on standing grounds in Murphy versus Missouri in 2024, meaning it did not reach the constitutional merits. The underlying coordination revealed through discovery was not vindicated. It was simply not adjudicated. Technically, no law was passed. Practically, speech was policed. The First Amendment bars government censorship. It does not bar government from recommending what private companies should censor on its behalf. The barrier remains, the speech flows around it. The Fourth Amendment protects against unreasonable searches and seizures. It requires warrants based on probable cause. In 1967, the Supreme Court expanded this protection beyond physical spaces. In Katz v. United States, the court held that the Fourth Amendment protects people, not places, that a reasonable expectation of privacy triggers constitutional protection even in a public phone booth. But subsequent rulings created a massive exception, the third-party doctrine. In United States v. Miller, 1976, the court held that bank records were not protected by the Fourth Amendment because the customer had voluntarily shared that information with the bank. In Smith v. Maryland, 1979, the court held that phone numbers dialed were not protected because the caller had conveyed them to the phone company. The principle was this: information voluntarily shared with a third party receives no Fourth Amendment protection, even when such sharing is practically unavoidable. Don't know how you make a phone call without using the phone numbers. Consider what this means in 2025. You cannot function in modern society without sharing information with third parties. Your bank knows your income and spending. Your phone company knows your location. Your email provider knows your correspondence. Your search engine knows your curiosities. Your social media knows your connections, your interests, your photographs. Under the third-party doctrine, none of this receives Fourth Amendment protection. You have voluntarily shared it. When third-party meant a single bank teller knew you by name, this doctrine was manageable. When third-party means every device and every application you touch, the doctrine eviscerates the Fourth Amendment in practice, while maybe leaving it intact on paper. The barrier remains, the surveillance flows around it. And the Fifth Amendment. Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law. This is the barrier against arbitrary government action. In 1970, the Supreme Court gave the guarantee new force. In Goldberg v. Kelly, the court held that welfare benefits, once granted, could not be terminated without a prior evidentiary hearing. The recipient had a right to confront evidence, present witnesses, and receive a decision from an impartial official. We discussed Goldberg extensively in part 1 of this series. It transformed welfare from charity to entitlement, from policy to property. But 6 years later, the court began to retreat. In Matthews v. Eldridge, 1976, the court established a new framework for determining what process is due. Rather than requiring hearings before deprivation, the court adopted a balancing test, weighing the private interest affected, the risk of erroneous deprivation, the probable value of additional safeguards, and critically, the government's interest in administrative efficiency. Under Matthews, efficiency became a constitutional value. The government's convenience could be weighed against the citizen's rights. This framework now governs everything from benefit denials to no-fly list to asset seizures. The question is no longer what process does the citizen deserve, but what process is the government willing to provide? The barrier remains. The administrative state flows around it. The modern American does not meet the government in court or in Congress. He meets it through forms, portals, and data feeds, an endless choreography of authentication. Considering what interacting with government actually looks like in 2025, you need unemployment benefits, you create an account. You verify your identity through a private contractor. The system cross-references your social security number, your employment history, your banking information. Algorithms assess your claim. If something does not match, a middle name spelled differently, an address from years ago, your claim is flagged, perhaps frozen, perhaps denied. You do not speak to a person. You do not receive a hearing. You receive a status update, pending review. Additional documentation required. Claim denied. See error code 47B. You can appeal through another portal with another form to another algorithmic assessment. Government no longer commands, it administers. You do not stand before authority, you upload to it. That might sound civilized, but it's far more encompassing than traditional governance. Law once stopped at your front door. Administration travels with you in your pocket. Every service, a loan, a job license, a healthcare plan comes with a quiet exchange. Convenience for transparency. Justice Louis Brandeis called it a century ago, the right to be let alone. That right has been traded for the right to be constantly evaluated. Let me give you a concrete example of how due process has been administratively circumvented. Civil asset forfeiture was designed as a tool to cripple drug cartels. The theory was simple. If you could seize the assets that funded criminal enterprise, you could disrupt those enterprises even when you could not convict individuals. But civil forfeiture does not require conviction. It does not require arrests. It requires only suspicion. Between 2000 and 2019, according to the Institute for Justice, federal and state governments confiscated over $68 billion in cash and assets through civil forfeiture. $68 billion. Much of this was seized from people never charged with any crime. A motorist stopped for a traffic violation carrying cash to buy a used car. A small business owner making regular bank deposits that happened to be under the reporting threshold. A family whose home was seized because a relative allegedly dealt drugs from the property. To reclaim what is yours, you must navigate the same agency that took it. Hearings without juries, deadlines that run out before your paycheck clears, legal fees that exceed the value of the seized property. The Fifth Amendment guarantees that no person shall be deprived of property without due process. Civil forfeiture provides process, technically, but it's process designed for administrative convenience, not individual rights. Here's another example. After September 11th, the federal government created the no-fly list, a registry of individuals prohibited from boarding commercial aircraft in or bound for the United States. The concept is straightforward: prevent known or suspected terrorists from flying. The implementation is Kafkaesque. Tens of thousands of travelers have discovered they are on the no-fly list, sometimes for a typo, sometimes for sharing a name with someone else, sometimes for a reason they have never been told and cannot discover. This includes, by the way, our Director of National Intelligence, Tulsi Gabbard. In 2014, a federal judge ruled in Lateef v. Holder that the list's redress system violated the Fifth Amendment. Travelers could not learn why they were listed, could not examine the evidence against them, and could not meaningfully challenge their inclusion. The government promised reforms, some were implemented, but the fundamental structure remains: an administrative list compiled in secret with consequences that can destroy careers and separate families, and no meaningful adversarial process. You can appeal, but you cannot know what you are appealing. You can contest, but you cannot see the evidence that you must rebut. This is due process in name only. Now, we discussed this in episode 2, but it bears repeating in this context. The Bank Secrecy Act dramatically expanded after September 11th. It requires financial institutions to file suspicious activity reports on transactions that appear unusual. In 2022, American banks filed more than 20 million SARs. 20 million reports on American citizens without warrants, without probable cause, without notification. Every deposit and withdrawal flows through the lens of potential guilt. Your bank does not just hold your money, it watches your money. It reports your money to the federal government. The Fourth Amendment requires warrants based on probable cause before searches. The SAR system operates without warrants, without probable cause, and without any search, because you have voluntarily shared your financial information with a third-party institution. The barrier remains. The surveillance flows through your bank. What do these examples have in common? In each case, the citizen has become something different from what the founders imagined. The founders conceived of citizens as rights bearers, individuals with inherent dignity whose relationship to government was defined by enumerated powers and explicit prohibitions. The modern administrative state conceives of citizens as credentials, data profiles to be scanned, verified, and assessed before access is granted. You do not have a right to fly. You have conditional permission revocable by administrative determination. You do not have property in the traditional sense. You have assets that can be seized upon suspicion and returned, perhaps, after administrative process. Each program was created for an ostensibly noble purpose: to stop crime, fight terror, prevent waste. But together, they have redefined citizenship as a status to be managed. You no longer stand equal before the law. You're profiled by it. Government does not need to silence you when it can simply limit your access. Freedom is not abolished, it is credentialed. That's the genius of management. It feels like a service. You rarely notice it until you fall outside of its parameters. And by then, there's no courtroom left to appeal to, only a customer service queue in the cloud. Now, as in previous episodes, intellectual honesty requires that I present the opposing argument fairly. Here's the security state justification stated as strongly as I can state it. First, civil asset forfeiture targets drug cartels and criminal enterprises that would otherwise be untouchable. Convicting kingpins is difficult. Witnesses are intimidated, evidence is destroyed, trials take years. Asset forfeiture allows law enforcement to disrupt criminal operations immediately, depriving them of the resources they need to function. Second, the no-fly list prevents terrorism. Even if one attack is prevented by keeping a dangerous individual off an aircraft, the list has justified its existence. The alternative, waiting for proof beyond reasonable doubt before acting, may be constitutionally pure, but it is also potentially catastrophic. Intelligence is often incomplete. Connecting the dots requires acting on suspicion, not certainty. Third, the suspicious activity reports track money laundering and terrorism financing. The September 11th hijackers moved money through the American banking system before their attacks. Financial surveillance helps networks be identified before they act. The 20 million SARs filed annually are not accusations, they're data points that may, in combination, reveal threats invisible to a single observer. Fourth, modern threats require modern tools. Terrorism operates across borders through encrypted communications using financial systems designed for speed and anonymity. A constitutional framework designed for the 18th century cannot constrain 21st century adversaries. Adaptation is not abandonment, it is survival. And fifth, each of these systems include procedural safeguards. Civil forfeiture can be contested, no-fly list inclusion can be appealed, SAR data is subject to access controls. The protections may be imperfect, but they exist. Perfection is not the standard, reasonableness is. That is the strongest case I can make for the administrative security state. Now, libertarians and constitutional libertarians and civil libertarians offer several responses to this defense. First, these justifications address symptoms rather than causes. They explain why individual tools might be useful in individual cases. They do not address the cumulative effect of combining these tools into a unified system of managing citizenship. A surveillance state is not the sum of its parts. It is something qualitatively different from any single program. Second, each system operates on a presumption of guilt rather than innocence. Asset forfeiture seizes property before conviction. The no-fly list restricts liberty before adjudication. Financial surveillance monitors transactions before suspicion. The constitutional order presumes innocence. The administrative order presumes risk. Third, procedural safeguards that exist in theory often fail in practice. The individual facing asset forfeiture rarely has resources to contest seizure effectively. The traveler denied boarding cannot meaningfully appeal a secret determination based on secret evidence. The citizen whose SAR triggered an investigation may never know it happened. Processes that cannot be accessed is not due process. Fourth, the argument that modern threats require modern tools proves too much. Every generation faces threats. Every government claims its circumstances are exceptional. The question is not whether these threats exist, they always do, but whether constitutional limits can survive the claim of emergency. If the answer is no, then constitutional government is merely a fair weather arrangement, abandoned whenever storms appear. Fifth, and most fundamentally, these systems treat all citizens as potential suspects. 20 million SARs fight annually. are not filed on known criminals. They're filed on everyone whose transactions appear unusual, which in a nation of 330 million people means millions of innocent citizens are reported to federal databases every year. The founders understood that liberty depends on friction. They designed a government that was difficult to move because they knew that government which moves easily moves towards control. The welfare security fusion has eliminated that friction. The citizen encounters government through seamless interfaces, portals that authenticate, algorithms that assess, systems that approve or deny without human intervention. It is efficient, even convenient. It is comprehensive. And it is fundamentally incompatible with the constitutional order the founders designed. Hamilton warned in Federalist Number 8 that fear of danger is the most powerful director of national conduct. Madison reminded us that parchment barriers alone cannot stop ambition. Their words read like prophecy. We have not repealed the Bill of Rights. We have simply routed around it. Now let me draw together the threads of this episode. The founders designed a constitutional order built on barriers. The First Amendment protected conscience. The Fourth Amendment protected privacy. The Fifth Amendment protected process. Together, they defined a space in which the individual remained free from government administration. Over 2 centuries, those barriers have been circumvented, not repealed, but routed around. Free speech now flows through platforms subject to government pressure. Privacy has been gutted by the third-party doctrine and financial surveillance. Due process has been subordinated to administrative efficiency. The welfare state and the security state have merged into a single system of managed citizenship. The databases that track benefits now communicate with those that track threats. The citizen who was once a rights bearer has become a credential, a data profile to be verified before access is granted. This transformation occurred gradually through reasonable sounding reforms, each justified by genuine concerns. It occurred not through tyranny, but through administration, not through oppression, but through efficiency. Liberty was never designed to be efficient. It was meant to be frictional, messy, argumentative, full of pauses. We have traded that friction for seamlessness, and in doing so, we have made ourselves easier to govern and harder to free. I want to drill in on that last point. Many folks accept where we are today as a result of the circumstances, the emergencies that led us here. Those same people, that same mindset, will they accept a state that only allows them access to earning an income, applying for a mortgage, accessing credit, on their acquiescence to whatever the government program of the day is? These are not hypotheticals. These are programs that are being run in other countries currently. The surveillance of your systems enables the government to monitor your compliance. And if you are non-compliant, you may no longer have access to the tools that make modern day life livable. We've made ourselves easier to govern and harder to free. Next time on episode 5, the COVID state, technocracy, lockdowns, and the politics of fear. In March 2020, a virus did what no army, ideology, or recession ever had. It shut down the United States. Churches closed, families were separated. The definition of essential became a category of citizenship. We will examine how emergency powers perfected over decades were deployed in weeks, and what the pandemic revealed about the administrative state's capacity for control. Thank you for joining me on this journey through constitutional history. I am Jeff Kellick, and this has been The New Leviathan, from 9/11 to COVID and the return of emergency power on the Consequential Actions podcast. If you enjoy this type of content and exploration of history, please be sure to subscribe at our Substack page at consequentialactions.com and our YouTube channel as well. And check out our written articles. From our corresponding article series on the New Leviathan to our prequel series on the General Welfare Clause, as well as detailed analysis of U.S. political theory, economics, and technology. We continue to post articles and welcome your participation at consequentialactions.com or follow me on X at jkellick. Until next time, have a great day.